I recently consulted with a guy who wants to marry his fiancée abroad in her home country. They are actually already have a wedding date scheduled. And she has a tourist visa to enter the United States. And their plan is to get married abroad, to enter the US with her tourist visa, and then to apply for her green card, her adjustment of status from within the United States. And this got me started on a conversation about immigrant and non-immigrant and fraudulent intent. And that's actually what I want to quickly repeat here for you guys. I've done other videos on this, but it's been a while, and it's particularly important now under the Trump administration's policies for you to understand immigrant and non-immigrant intent, because it can end up getting your green card application denied if you don't understand these topics. When you enter the United States with a non-immigrant visa, and the two most classic examples are a tourist visa or a student visa, you must have non-immigrant intent. In fact, the customs officer at the port of entry, whether it's the airport or if you're driving in through a land crossing in Canada or Mexico, the reason why they ask you where you're going, what your plans are, and other questions is primarily to determine whether you have non-immigrant intent. The intent to depart the United States after this brief entry. And in the case of a student visa, it might not be a brief entry. You could stay for your duration of stay as long as you remain in status, but you must still have the intention to not permanently live in the US. If you have the intention during this entry to permanently live in the US, that's considered immigrant intent. And you should not be allowed in as a tourist, for example, if you have immigrant intent. In fact, in the airport, the customs officer can put a stamp canceling your visa. They could cancel it without the stamp. They can cancel your visa. They could determine that you had fraudulent intent and render you inadmissible for several years, where you literally cannot come back to the United States during that period of time without a waiver. And this could totally mess up your plans for the future. So the key thing to understand is when you enter as a tourist, you must have non-immigrant intent. You cannot at that moment intend to permanently live in the United States. However, after you enter with non-immigrant intent, if your intent changes and you later decide you want to permanently live here, then you can lawfully change your intent and apply for permanent residence. Let me give you an example of how this might play out. Let's say you have a US citizen boyfriend and you are outside of the United States and you want to go visit your boyfriend. Fine, that's perfectly legal if you have a tourist visa. So you get to the US, the customs officer asks you what your plans are, and you say, I'm visiting my boyfriend and we wanted to go visit this national park, and this is our itinerary, and I plan to leave in 2 months. And the immigration officer says, okay, I'll give you the full 6 months, but you should leave after 2 months. Now, after being in the US for 6 weeks, your US citizen boyfriend proposes to you, and you guys decide you want to share the rest of your lives together. And now you guys have to decide, should I leave the United States and do this entire immigration process through the consulate abroad, or can I apply for adjustment of status in the United States? And you speak to an immigration lawyer like me, which if you want, you guys could always schedule a consultation. My info is in the video description below. And after speaking with me, you learn that you can safely apply for adjustment of status in the United States. And that ideally, we want to wait until after you've been in the US for 90 days before you take any action that suggests that you plan to permanently live in the US. So after day 90, you guys get married, and then let's say around day 100, well within the 6-month duration of stay that you were afforded, you apply for your adjustment of status. The moment you apply for adjustment of status, which is permanent residence, a green card in the United States, there's a couple things. First of all, your tourist visa is effectively canceled because you no longer have non-immigrant intent. So you can no longer travel easily back and forth. You can apply for something called advanced parole, which gives you permission to travel internationally, but it's super risky, and I don't recommend actually traveling on it unless you understand the risks involved right now. Effectively, you should plan to remain in the US continuously until you get your green card in this scenario. If we also apply for your work permit, which I do recommend, typically like 3 to 4 months later, you'll receive your physical employment authorization card in the mail, and usually a few weeks after that, a social security card. There have been some changes with the issuance of social security cards. If your card doesn't arrive within like a month of getting your work permit, we can contact the Social Security Administration to get your card issued. And now you guys can pretty much just live your lives together until your green card interview is scheduled. After you attend your interview, if all goes well, typically within a month you'll have the physical card, and then you can talk to an attorney about traveling internationally and what risks might be involved there. A question that people regularly ask is, yeah, but after that 6 months is up in this hypothetical scenario, wouldn't I be unlawfully present in the US? And the answer is no. As long as you applied for adjustment of status while you were in the duration of stay for your tourist visa, which in this example was the full 6 months that the immigration officer at the airport provided, then you will be lawfully present the whole time. You will not accrue any unlawful presence while the case is pending. And if your green card gets approved at the end of the case, then you'll never have had any unlawful presence while in the United States. All right, guys, so just to summarize, if you enter the US with a tourist visa, but your secret intent the whole time is to permanently live in the US during that entry, that's considered fraudulent intent. And that could be a basis for which your green card could be denied and a fraud determination can be made. And even if there's no fraud determination made, a denied green card application right now can result in removal proceedings, deportation proceedings. So if you need any assistance with your marriage-based green card or family-based petition or naturalization, be sure to reach out to me. My information is in the video description below. I would love to speak to you about your case and represent you throughout the entire process. If you're new to my channel, I make videos on a weekly basis about family-based immigration, naturalization, and changes to immigration law under the Trump administration. If you're interested in learning more about these topics, be sure to subscribe, and I'll see you guys next time for another video.